I'm going to take my phone out, not because I'm texting, but because I'm going to put a stopwatch on, just so I make sure I don't keep you guys too long. So I thought I'd talk about three different topics quickly today. First, a little bit about Justice Stevens' book, about Justice Stevens' process of writing, and then a few general observations. But before I get that part started, a couple of thank yous. I want to thank Professor Stearns for moderating the event, for putting it together, Maryland for hosting us here. It's been a wonderful afternoon. A number of professors that have come down to hear us, so thank you for the familiar faces. And most of all, I have a former student in the crowd. I won't embarrass her by calling her out, but I'm very grateful that she has signed up for a second tour of duty, this time when I'm not grading. Thank you all for being here. As Professor Stearns said in his introduction, it is an interesting phenomena, the rise or growth in books that are written by justices of the Supreme Court. We don't really usually think of them as writing books. We think of them as writing opinions. And what's interesting is that phenomena is actually not just one that's present in the United States, but it's actually one that is happening around the world. There are more, I haven't measured this empirically, but just looking at what's going on, there are more books, I think, now being written by Supreme Court justices around the world than at any time. And they're trying to explain their jurisprudence, and sometimes they're trying to talk to people in their country, and sometimes they're even trying to talk to each other. So the complementary book to Justice Breyer's that's written by the former president, that is the Chief Justice of the Israeli Supreme Court, Aaron Barak, is called The Role of a Judge in a Democracy. And it's his notion of how a judge ought to function. But it is this interesting phenomena that we've seen more of around the world. And I'll talk a little bit briefly at the end as to why I think we might be seeing a little more about that. But to talk about Justice Stevens' book. So his book, which, by the way, if you're going to read one book for fun, I know you're all busy this year, I recommend reading Harry Potter. But if you read two books for fun, then you should read, the second book you should read should be Six Amendments by John Paul Stevens. It is eminently readable. It's actually fun, I promise. You can take my word for it. I've read it a few times. And it very much captures Justice Stevens as a jurist. It is not, as with Justice Breyer and Justice Scalia's book, a book on its face that talks about his overriding theory of constitutional or statutory interpretation. But I think that when you kind of sift through his 6 proposed changes to the Constitution, which I'll talk about in a second, you get a feel for why he thinks they should be changed and how the court got things wrong. And in looking at his explanation for where the court got things wrong, you actually get a good understanding, I think, of him as a jurist and what he finds jurisprudentially important. He tends more toward the Justice Breyer school of thought, but most of all, I think if you read the book, you'll see there's just a certain common sense, at least I like to think common sense, that echoes through in the book. It's a certain diligence, it's a carefulness, but it's also, he tries to just explain very clearly and coherently why he thinks in a particular situation, a particular outcome is the right and legal one. So his 6 proposed changes are, first, and I should add, this was not the order that his law clerk recommended they go in, but it's more of a reminder that he's the one that's appointed by the president and confirmed by the Senate, not us, so he gets to make those decisions. So the first is he would amend the Constitution to get rid of the so-called anti-commandeering rule. That's a rule that prevents the federal government from requiring the states to do certain things. Most recently, and I'll sort of circle back around to this at the end, created a problem for firearms registration when the state wanted the federal government wanted state officials to carry out a database registration, and it was difficult to do because the Supreme Court said, no, you can't require the states to do certain things. The second is he would make political gerrymandering, that is the drawing of odd political districts, a justiciable question. That is one that can be decided by courts, and he would require that they be compact and contiguous, also known in normal parlance as ordinary shapes. The third is he would amend the First Amendment And a lot of you are probably familiar with his dissent in Citizens United, where he talks about corporate speech. But he wouldn't just change Citizens United. He thinks that the original problem is a case called Buckley versus Vallejo, where the court said that campaign donations, that is, when you give money to a campaign, those can be restricted, but campaign expenditures, that is, when a candidate decides to spend money, those can't be restricted. And he thinks that that's a distinction that doesn't really make good sense in the campaign finance realm, and so he would have the First Amendment changed to overturn the court's interpretation in Buckley. The fourth is sovereign immunity. It's a doctrine about when you can sue the state for doing certain things. He would basically, if the state runs, say, a hospital, he would have the state be equally liable as a private individual would. The fifth is he would repeal the death penalty, which, as he says in his book, would hasten its demise. And it's actually an interesting instance where Justice Stevens, who was a member of the court that voted to reinstate the death penalty, so when the death penalty had been suspended in the United States, he was a new justice. He had voted to reinstate it. And he says in here, as he said in one of his final years on the bench, he thinks that was a mistake. He voted wrong, and so he would make it clear that the death penalty is cruel and unusual and prohibited by the Eighth Amendment. And finally, he would amend the Second Amendment to allow for gun control, to return it to his understanding of the original intent of the Second Amendment in his dissent in Heller. Depending on your point of view, 6 reasonable, moderate, pragmatic considerations, or 6 attempts to tear down the American Republic. Take your pick. Those are his 6. A little bit about his writing process and the process of working with the justice. So, as Professor Stearns alluded to, we all had wonderful jobs. We had great bosses. They're all, I think, take real care and time and really like their clerks, and they're brilliant and fun to work with. I had I think, a particularly great time because in addition to working with Justice Stevens, I actually spent most of my time with Justice Kennedy, where we were working on the regular merits stuff, but then also with Justice Stevens on the book. And basically, the writing process went something like this. Justice Stevens was, at that point, 93 and a half. As you can imagine, the writing process with a 93-and-a-half-year-old is very much what you would envision. I would be working on something for Justice Kennedy, and Justice Stevens would either call or just pop in. We shared a door in our office, and every time he came through the door, it was kind of like startling, right? It's like a piece of living history that's walking through the door. But he would poke his head in and say, "Oh, I finished a chapter and I put it in the share drive. Have a look at it and let me know if you think any changes should be made." That is to say, it was incredible. He just kind of fully done. These things would drop down. And I mean, how are you going to edit as a 30-year-old young John Paul Stevens, right? Like, oh, this one about Citizens United, you did a pretty good job there, boss. Like, it was very difficult on one sense to really offer constructive criticism to him. And he would keep pushing back. He insisted on calling it our book. The thing that I did the most on were the captions for the book. But he would keep pushing back and saying, like, no, you really need to, like, let's tear it apart. And so we had these long conversations, which were a lot of fun, about the amendments and his theory behind them. But it's actually kind of incredible to see him at work. I mean, he really is a true genius. And all of the justices, I think, as Thruitt said in our afternoon session, are really impressive. And Justice Stevens, it was just incredible. I mean, at 93 and a half. And then he would say something like, "Okay, I'm going to go play 18 holes of golf." I mean, it's like, it's really just an incredible thing. And he's a wonderful man. So that was the writing process, which is to say, I didn't do very much writing. A couple of observations to close. So the first thing is, why are the justices writing these books? And I think Professor Stearns alluded to it a little bit, which is the notion justices in our system and most systems generally decide cases that are before them, so they can only decide an issue that's presented. That means that if they want to say something else, they can sometimes put it into a separate writing, but usually they can't. They've just got to wait for the case. This means that it's difficult sometimes to get all of your thoughts together in one coherent place, and it's difficult to be able to make your argument, especially if the arguments are cross-cutting. And so as a result, I think that they like the idea of being able to really say a clear theoretical underpinning or to weave similarities between seemingly disparate areas of the law. So Justice Stevens sort of draws analogies as to how the court may have gone wrong in the context of anti-commandeering, in the context of sovereign immunity, political gerrymandering. These are, as you might imagine, not issues that often arise simultaneously in the same case. And so he doesn't usually have an opportunity to talk about them. And I think that's part of the attractiveness for Justice Breyer and Justice Scalia. The second reason is I think it's important to remember that these are people who live their lives by the written word. This is how they are used to interacting with the world. They interact through the writing in their opinions. And that tends to be how they get their point across. They don't give public speeches when they hand down the opinion. They'll read a little bit from the bench, but it's really their writing that they live through. So this is just their way of thinking about things. Writing is how they interact in the same way that law professors tend to write articles. And so I think that that's another reason that they're writing the books. And on the law professor note, I want to close by saying thank you all for coming here today. I had a wonderful time. As Rebecca said, I think clerking for the Supreme Court is a fantastic job, but there are some days that I think that the best job I had was the semester I spent at Maryland. So it's great to be back here, and thank you all very much for listening to us.